Appears that we have both counsel on this matter. This will be Chen and McElveen. Counsel for the appellant, would you help me out here for a moment? I try hard to pronounce surnames correctly, as you can tell from mine. So if you'd help me out.
Jeff Picard.
Picard. Thank you, counsel.
Thank you. May it please the court?
Did you wish to reserve any time for rebuttal?
5 minutes, please.
Okay, thank you, sir. And you may proceed.
Thank you. I represent the appellant Yingkai C. Chen in a landlord-tenant action that was brought related to a security deposit in small claims court. And the issue before this court is whether it was proper for the judge to exclude evidence that my client was intending to offer at the final hearing, the trial, relative to.
But Mr. Picard, that evidence was attempted to be offered at the end of the entire proceeding. End of all the proceedings, the very end of the hearing, after the judge was in the process of presenting her findings. In other words, it was over. And now at the very last second, your client, who is represented by a doctor who is not a lawyer, I don't know how that happens. I think that's unlicensed practice of law, as far as I understand it. Basically, after the horse is out of the barn, out of the corral, and into the next field, wants to now bring in this evidence.
Well, Judge, the issue is, and I know that it's new for this court to handle direct appeals from small claims court, but the rules in small claims court are different than the rules of civil procedure. And I believe under the rules of small claims court, you can proceed pro se. And he's a representative of the company, and he was proceeding pro se. And so,
well, I understand pro se, and to help you, Mr. Picard, I was a county judge, so I understand the rules of small claims. Okay, I got this, but it wasn't clear from what I read that he was anything other than a friend or somehow connected with Chen. I didn't understand that he was actually an owner. That's what you're telling me now?
I believe that he's an officer. I'm not quite sure if he's an owner. The record doesn't reflect that, but I believe that he is at least an officer of the company.
Well, if the record doesn't reflect it and you believe it, that means then we don't have that information. Okay.
Right.
And I do remember saying there was something in there that I read that there was some relation or ownership, but I think that you set that aside. I also have some history. I was on the small claims rules committee and chaired it back when they were adding these provisions. And one of the important things that everyone talked about then is if people go forward and represent themselves, then there's dangers and they need to be aware of those dangers. And isn't that what we're facing here, is that somebody went forward and thought, I can handle this myself, put up what they thought was the best defense, but didn't bring up what might have been the best defense in a timely manner.
Well, that's true, but I don't know that it was not provided in a timely manner. Under the rules of civil procedure, there's no defensive pleading. So it's not like you have to provide an answer like you would in a circuit county court or circuit civil court. And so the time that you present the defense is at the final hearing. And he did try to present, obviously the record does reflect that he tried to present it at the final hearing, which would have been the time to bring that. You necessarily would have. It's not like
after all the evidence had been, after all the evidence that was already in, it was over. The opportunity to present evidence had closed.
Well, I guess I'm not quite clear of that on the record. I know that it was right before she was going to issue a ruling. Obviously, the rules do contemplate when there's an unrepresented party that the trial judge is to assist the unrepresented party on presentation of evidence. And I'm not quite sure.
There's a big difference between that and becoming their lawyer, though. I mean, this is different than what you're suggesting. It would be inappropriate for a judge to be basically asking, well, okay, have you got any more evidence? I mean, how would the judge even know about this issue? I mean, the issue was unknown to the judge.
Well, it was known for purposes. There was a pleading that was filed in October, which would have been almost a year before the hearing, answering affirmative defenses that were asserted by the appellee, where they acknowledged that the property had been sold. So it was in the pleadings themselves. And it is true that my client didn't raise it until, I guess, towards the end of the hearing, but he did try to raise it. It was a known issue prior to the final hearing on it. And he was trying to raise the issue. Obviously, he was proceeding pro se, and he was attempting to advise the court of it, because obviously if the property had been sold, then and it has been, and the judge was to hear it, we believe it would have changed the outcome, because the lease agreement between the parties indicates that if there was any dispute, it would be brought against the record owner.
Then why was not that new owner a party to this action? Chen, the plaintiff in the action, was seeking the deposit for herself or for her company. She wasn't seeking it for somebody else.
Well, the counterclaim that was filed related to the security deposit, I believe, was on behalf of the property manager, which I think was still the property manager for.
We still don't have the new owner involved, right? I mean, what you're telling me is the new owner is the party in interest, and the new owner is nowhere in these pleadings.
Correct.
Okay, so Chen was seeking the deposit for herself or for her, her LLC or whatever the entity was.
Well,
she didn't say I'm seeking it for them. She was trying to recover it herself.
Well, they already had the security deposit. So they weren't seeking I guess when they filed the counterclaim,
they're seeking to retain it.
Well, the amounts that were identified as part of the counterclaim were amounts that, if you look at the documents, were incurred by the property manager, which is a separate entity. And so I think that what happened is he believed there was a compulsory counterclaim, felt like he had to bring it as part of it. And obviously he was raising this defense, which again, if he had an attorney, I would have told him up front, you need to raise this immediately, because I think it's a game changer with respect to it. But he was proceeding pro se. Obviously he didn't have the legal basis and know-how that he needed to raise it at the first instance. But he did try to raise it before the judge issued a ruling. And for that reason, we believe it's an abuse of discretion, because if it was seen, we believe it would have changed the outcome.
Which means no other reasonable judge would have made the call that Judge Peroni made. Right?
Well, we think
that's the standard. No other reasonable judge would have made the call that Judge Peroni made.
Yes,
that's what you have to convince us of.
Right. And the thing is, they're proceeding pro se. And so obviously he doesn't have the legal education or background to know when he needed to present it. He did try to present it before the judge made a ruling on it. And it was something that would have been dispositive of the issues, because there's a lease agreement. Action would lie with the record owner. He wasn't the record owner at the time that the security deposit was even an issue. He also wasn't the record owner at the time the lawsuit was brought. And then there's also a statute that deals with it, the 83.49, dealing with security deposit. It talks about if a seller sells the property, the buyer then assumes the security deposit, and it creates a rebuttal presumption that this happened, that the security deposit was transferred from the seller of the property, my client, to the buyer of the property. And based upon that, he wouldn't be in possession of the security deposit.
And remind me of the notice that Chen gave to the tenants about the transfer of the deposit.
I'm not sure that he provided notice on it, but I don't think the location changed. I think the property manager, it's my understanding that that didn't change, because the property manager was holding the security deposit.
Okay, you got the same person holding it, but you have a change in the person who has a right to claim it, right?
But I don't think under the statute he's required to provide notice pursuant to, I believe it's subsection 2 of that statute. I don't think the notice is required unless you're changing the location or the manner of it. And it wasn't being changed. It was still in the same location. It was being managed by the property manager, who took over for the buyer of the property as well.
Okay, and remind me the evidence that was introduced in court about the lease being assigned. Property changed hands. Was a lease assigned?
It was part of the contract that was applied, that was presented as part of our motion for a new trial to consider the sale.
The motion for new trial, but it wasn't in the final hearing.
No, because the client was trying to present that evidence and the judge didn't allow it. And so when I was hired and brought on, that's when I filed it, because the documents do reflect that it was assigned to the buyer as part of it. And then the buyer assumed that provision of it also consistent with 83.49. And so, obviously, if my client was allowed to present the evidence of the sale of the property, we believe it would have changed the outcome. And unless I have further questions, we would ask that the case be remanded back and he be allowed to present this evidence. And I'll cede my time to the appellees.
Thank you, counsel. Counsel, I want to ask you the same question because I want to make sure I do it right. Is it pronounced Giuliano?
That's correct, Your Honor.
My mother was Italian.
Oh, well, thank you. Again, may it please the court. As stated, my name is Amanda Giuliano. I represent the appellees, Christopher McElvin, Charles Winston, Tyler Cannon, and Tyler Foss, the tenants and plaintiffs in the lower court who seek for this court to affirm the final judgment entered in their favor. Your Honors, there's a lot of parties involved. I'm going to try for ease of all of us to refer to the appellees as the tenants and the appellant, Ying Kai Si Chen, as Ying Kai. I do want to, before I get into my main argument, make a few clarifications on the parties in this matter. Ying Kai Si Chen, Ying Kai, was the original owner and landlord of the property. The property manager was Silicon Valley Real Estate. It's important to note that Ying Kai and Silicon Valley were owned, or at least the same officer for both entities, which was Kai Deng, also known as Peter Deng, the individual who proceeded in this litigation throughout the entire process. And that can be seen on page 15 of the record, the signature page of the lease. Your Honors, the final judgment that was entered by the lower small claims court after a year-long litigation and 2-hour evidentiary hearing was proper and should be upheld. As mentioned, this was not a matter of Ying Kai simply defending against an action that was brought against it. It actively participated in prosecuting its own claims, to go to Judge Morris's point, in its name to retain the security deposit and additional damages to the property. The appellant would like this court to believe that it was a simple pro se defendant that was precluded from raising or introducing what it now contends was pertinent evidence that would have absolved it from liability. But in actuality, Ying Kai, through its principal, Kai Deng, actively participated, engaged, and prolonged the litigation and was given ample opportunities to raise the issue of the third-party buyer. Simply by participating in the litigation as both a defendant and counterplaintiff, Ying Kai affirmed to counsel and importantly to the court that the proper party was actually named in the suit, namely Ying Kai. Our answer brief goes through many of the facts in this case. I do want to just point out a few which I believe are important for this morning. The lease was entered into between the tenants and Ying Kai. When it came time for the lease to terminate, Kai Deng, Dr. Deng, is the individual who attempted to negotiate the new lease with the tenants. And when they did not agree, he threatened to charge them $160 per day that they remained on the property. And such demand was in contravention of the lease. Again, a security deposit statement was sent, which was not in compliance with Florida law. And it was claimed that the landlord would be retaining the security deposit and seeking additional damages. The tenants did file the suit in August 30th, 2019, naming Ying Kai, which was the entity that it was in privity with, because they had received no notice at any time that the property had been transferred. At the preliminary hearing on October 1st, 2019, Dr. Deng appeared on behalf of Ying Kai. He denied the allegations. He stated he would be filing a counterclaim and at no time informed the court that he believed the wrong party was sued or asked for the case to be dismissed. Instead, he went ahead and filed that counterclaim and stated in the counterclaim he was appearing on behalf of the landlord, Ying Kai, and he sought forfeiture of the security deposit and additional damages in its name. As counsel pointed out, we did file our answer and affirmative defenses in that case. And upon a public records search, we did see that the property was transferred. So we raised it as a potential affirmative defense, not knowing if the lease agreement had ever actually been assigned. And we contend, Your Honor, in the record, there is no evidence of an assignment of the lease. Going on, more indication of Dr. Deng's participation in the litigation. There was a mediation on February 13th. Dr. Deng appeared. again, made no representation that Yinkai was not the proper party and had no authority to settle any matter, but instead proceeded to attempt to negotiate a settlement on both the tenant's claims for the security deposit and Yinkai's claims to retain the security deposit and additional damages. He filed multiple motions in the proceeding, including two to either postpone or cancel the claim. And importantly, he filed a motion for summary judgment, asking that the security deposit be allowed to be kept by Yinkai and sought additional damages. Not only did he prepare that motion for summary judgment, he prepared and submitted a proposed order to the court in Yinkai's name, granting them, the retention of the security deposit and the additional damages. Again, as we recognized, we had a 2-hour evidentiary hearing on September 2nd. Dr. Deng appeared. He also brought with him 2 witnesses and documentary evidence that was not only to rebut the tenant's claims, but to actively prove the Yinkai's claims for additional damages to the property. At no time did he ask any questions or introduce any evidence regarding the ownership of the property. As recognized, it was only when Judge Peroni began entering her findings and it became clear that the tenants were going to prevail, then and only then did Deng attempt to introduce the warranty deed and argue that Yinkai was not the proper party. The court did hear his statement. She allowed him to raise that issue, but then she continued to rule in favor of the tenants and followed that by a final written judgment. The appellant obtained counsel, Mr. Picard, and moved to set aside the final judgment. In support of that motion, it did attach a copy of the sale contract between Yinkai and the third-party entity, but notably failed to attach any assignment of the lease. The lower court denied the motion and it appealed. Your Honors, the lower court did not abuse its discretion in excluding the untimely evidence. Appellant attempts to categorize its failure to raise the issue of the third-party buyer as it being prevented from presenting evidence, but this is demonstrably false. Although pro se, it is not immune from the rules of civil procedure. Barrett versus City of Margate, 743 Southern 2nd, 1160, Florida 4th DCA, 1999. Here, appellant is a business run by a sophisticated business person who, by his own admission, owns several companies. In each of its briefs, appellant ignores the important fact that appellant was not simply defending an action. He was actively prosecuting claims in its name against the tenants. The appellant was obligated to raise the issue of this supposed indispensable party prior to the close of evidence at the final hearing. I'll cite to Valparaiso Realty versus Valparaiso, 473 Southern 2nd 1, Florida 1st DCA, 1985, where it was recognized that non-joinder parties is not a jurisdictional defect which may be raised at any time. Appellant also in its brief argues that an anti-waiver provision in the lease relieves the appellant of its duty to raise the issue prior to the lower court's ruling at the final hearing. However, the cases cited by appellant concern substantive waiver under contracts. For example, where one party accepts late performance by the breaching party. Here, there is a procedural waiver, the failure to timely raise an issue in the lower court. The appellant willfully chose not to raise the issue until it became clear it was not going to prevail. And not only were appellant's actions a waiver, they were at a minimum evidence of unclean hands or possibly an act of fraud on the court. Throughout the litigation, appellant has engaged in unconscientious and deceitful conduct, including actively prosecuting a claim it now asserts it had no standing to pursue. The lower court even recognized his actions as attempting to raise a, quote, gotcha defense. Despite appellant's claims to the contrary, these actions did damage the tenants. Again, this was not simply a matter of Yinkai defending against the tenants' claims. Yinkai was actively prosecuting its own claim for additional damages under its name. By prosecuting its claim and not informing the court that it believed it had a grounds for dismissal, it forced the tenants to incur additional time and attorney's fees defending against an action appellant now claiming it had no right to pursue. And to address the second argument of the appellants, even if the evidence had been admitted, judgment in favor of the appellant was not automatic. The appellant must establish that it is reasonably probable that a more favorable result would have been reached had the error not been committed. And this court also held in South Star Equity LLC versus Chow at 998 Southern 2nd 625 that judgment should not be reversed except where the error complained of has resulted in a miscarriage of justice, and that has not happened here. Despite appellant's argument in its brief, the language of the lease is not clear and unambiguous. Owner is nowhere defined in the lease. The definition of landlord in the lease states, quote, includes the owner, which is undefined, of the premises, its heirs, assigns, or representatives, and or any agents designated by the owner. It is not clear that the third-party buyer had any liability under the lease or was the proper party in this matter. There is no evidence that the lease was actually assigned. Although the appellant filed a copy of the sale agreement with the lower court, it notably did not file any assignment of the lease. In its reply brief, appellant points to boilerplate language in the form sale agreement that, quote, seller shall at closing deliver and assign all leases to buyer who shall assume seller's obligations. However, nowhere in the sale agreement is the lease referred to. Paragraph 6 of the sale agreement is the section where the seller informs the buyer that there is a lease on the property. That section is not checked and no information provided regarding the lease is provided. There's also no evidence in the record that the estoppel letters, which are required to be provided from the tenant under paragraph 18 of the sale agreement, were ever actually provided. And the tenants here were never asked to provide any. Without any indication that in the sale agreement that there was a lease on the property, the standard boilerplate language was not sufficient to assign the lease and all of its obligations thereunder without an actual assignment. This argument is not about the tenants attempting to enforce a third-party contract, but instead showing there is no evidence that any of Yinkai's obligations under the lease were assigned to a new buyer. As we've already mentioned, there was no notice to the tenant of change in ownership. The sale of the property apparently occurred prior to the end of the lease term and long before the litigation. However, Yinkai provided no notice to the tenants at any time during the lease term or prior to or during the litigation that there had been a change in ownership in the property. Dr. Dang was the party attempting to negotiate the new lease with the tenants. The move-out report that was provided to counsel in the court was provided by Yinkai through Dr. Dang. Further, as was mentioned, no notice was provided under Florida Statute 83.492 regarding the security deposit. Now, appellant has argued today and in its briefs that the security deposit never changed hands and was held by management. Well, again, management in this case is run by Dr. Dang. So we have another situation of Dr. Dang acting unscrupulously before this court. Dr. Dang is the principal of both Yinkai and Silicon Valley, the property manager of the residence. The email used on some of the Silicon Valley invoices, which is in the record on page 36, is the same email address used by Yinkai in this action, shown on the record in pages 63 and 263. So control of the security deposit has apparently been in his hands this entire time. And the lower court made specific factual findings that the tenants were entitled to their security deposit back, that it was improperly being withheld, regardless of who was holding it. Dr. Dang has denied and continues to deny the tenants the rightful return of their security deposit by manipulating language in the contract and also the legal system. His actions through his companies has further damaged the tenants by not only denying them return of the security deposit, which the lower court clearly determined they were entitled to, but through necessitating the spending of legal fees on this appeal. In conclusion, Your Honors, the appellant was not a simple pro se party, but a sophisticated business run by a sophisticated business person who sought to manipulate the legal system and deny the tenants the return of their security deposit. The appellant had ample opportunity to raise the issue of ownership of the property and willfully chose not to do so as a strategic decision. By actively participating and prosecuting its own claim against tenants, Yinkai has repeatedly confirmed to counsel and the court that it was the proper party in this matter. Appellate through Dang has come to this court with unclean hands and should not be awarded a second bite of the apple because of it. The lower court did not abuse its discretion in excluding the evidence. The tenants are entitled to a return of the security deposit, and the final judgment should be upheld. Thank you.
Thank you, counsel. Counsel, you have 5 minutes remaining for your rebuttal.
Thank you, Judge. The appellee's counsel mentions a waiver and talks about the actions by Yinkai Sichen were a waiver of their potential defense. However, the case law that's cited is not applicable to small claims court. It's talking about the Valparaiso case cites to Rule 1.140 of the Rules of Civil Procedure, which talks about joining an indispensable party. Obviously, the Rules of Civil Procedure don't apply, only a certain portion of them due to small claims court. That's not one of them. It's obviously further supported by the fact that small claims rules don't require a defensive pleading. So you don't have to present an indispensable party in any pleadings in response to a lawsuit. And as we mentioned before, there is an anti-waiver provision in the contract that prevents the waiver of any rights that Yinkai Sichen might have had, including the fact that the contract between the parties of the lease agreement clearly says that if there's any dispute, it's to be brought against the record owner, which in this case was the new buyer, Victory Height LLC. The contract between Yinkai Sichen and the buyer, Victory Heights, clearly has an assignment of the lease agreement. It's in paragraph 6 of the sales agreement, but it's also pursuant to operation of law that security deposit is transferred, and there's a rebuttable presumption that it is transferred from the seller of the property to the buyer of the property. So in this case, the statute provides that there's a rebuttable presumption that it is transferred from Yinkai to Victory Height, and Victory Height would be in possession of that security deposit. Appellee's counsel mentions that the owners or operators are the same and cites to some emails and the fact that the contract was signed by Peter Dang. Obviously, the individual that represented Yinkai in this action was Kai Dang. It's indicated in the record that he's the one that made the appearance. I don't know what relation Peter Dang has with Kai Dang. They may be related. They may be, I don't know the relation between them, but it's my understanding that these are separate entities. And obviously the entities do, I believe, have the same address, so they probably are somewhat affiliated, but they are separate entities, and the Silicon Valley is the one that would be holding the security deposit, and they were the ones that held it also for the buyer. And so this security deposit was always in the possession of the property manager on the case and not Yinkai. And so again, we believe that if this evidence was allowed pursuant to not only the contract but also to based upon the statute 83.49, it would have changed the result. And for that reason, we believe it's appropriate for the trial judge to consider the fact that this property was sold.
Thank you, counsel. Thank you both. As I'm familiar as I am with technology, I understand you'll be, is the right word, transported? It sounds like Star Trek, doesn't it? Transported to another location.